Hello, everybody. It is half past the hour, so I'm going to start. My name is Nicholas Georgakopoulos. Hello, and I have very little to do with math. I'm a law professor, so most law professors are math phobic. I'm just not math phobic. That's how close I come to math. I usually present this to legal audiences, and from my look at the people's list in Pathable, I didn't see any lawyers. So I'm very sensitive to the idea that you guys are coming with a different set of background concepts that may need us to converse. So I'm keeping a watch on the Pathable chat, and please put in your questions so I can address them. Also, as far as administrative matters go, I have in the Files tab this presentation that you can download, and I have the analysis notebook that does the analysis. In the analysis, the part that processes the database is remmed out, but you can see the idea is to see what it does. Anyway, so I call this chat the or I call this work the conservative paradox, median justice proximity, and principled interpretation. And the way that it would go for a legal audience is I would explain the background work that we have done. In some of these are with a co-author of mine. Essentially, there's a big database that has all the decisions of the Supreme Court and the votes of the judges. And we take the modern database, which is from the 1946 term, which means from October 1946 to the term before the last, and we focus on the 5-4 decisions, the tightly split decisions, to explore the multidimensionality of judging. It's law-centric. This is not political science. This is not math. It is. We're trying to understand the law part of it. And in the past, in past pieces that are part of this sequence, we have calculated what we call the fluidity index. Essentially, think of the court forming coalitions of 5 in several ways. If they only form one coalition of 5, Judge A with Judge B, C, D, and E are always the 5, and the other 4 are always the minority. That is the one extreme of the index. And the opposite extreme is that a proportionate number of opinions are issued by each possible coalition of 5. And the fluidity index places the court in that space. We've illustrated, made graphics essentially how the court produces opinions out of different coalitions of 5. In the case of criminal procedure, we identify 6 dimensions of it for the Indiana Supreme Court. We identify some dissenters who, when they leave the court, the statistics change because they were dissenting very vocally. And in the case of un-Americanism prosecutions, the McCarthy era after the Second World War, we see how the fear of communism changes the way the judges vote. But today, or this project, is about juxtaposing the multidimensionality of judging with the concept that we think of decisions as liberal or conservative. So the conservative paradox is that since the 1946 term, 5-4 decisions have leaned conservative, 58% conservative. I do chi-square tests on that. I show that the 5-4 decisions, the rightmost column here, has a p-value that's an extremely small number. So it's extremely unlikely that by chance this 58% could have come by chance, while the underlying mechanism is producing 50-50 decisions. Then I divide time into periods. This is essentially 3-term periods are too short. They have a lot of noise. So we see that when I group the decisions in 3 terms, they fluctuate a little bit. And from 1961 to 69, they actually lean liberal. But if I group them by 15-term periods, they're all leaning conservative. The percentage of conservative decisions are more than 50% always. And then I also do it by composition. Essentially, every time a new justice is appointed, until the next appointment, the appointment of this justice defines the 9 people who are on the court, the 9 members of the court. And we see that on each composition, the conservative ratio is greater than 50%. Each composition that issues more than 40 decisions. And I have 2 audits that seek to overcome the objection that calling something a conservative or a liberal decision is subjective. The next step is to sit back and think about why we might have such a bias. And theory doesn't offer anything. One possible candidate would be the control of the Senate. So justices are appointed by the president with the consent of the Senate, which means that the Senate has to vote in approval of the appointment. And the question here is, if there is a Senate from the opposite party, does that force the president to appoint someone more moderate, more centrist than the president would appoint if the president was facing a Senate of his own party? But the data here is the opposite from what the intuition would suggest. Essentially, in order to have a conservative bias, we would think that the liberal appointments have been more conservative than the conservative appointments have been more centrist than the conservative appointments have been centrist. But the Senate composition has been the opposite. Essentially, when Democrat presidents have been appointing justices since 1946, never has the Senate been Republican. But when Republican justices have been Republican presidents have been appointing justices, about half the time, the Senate has been Democratic. So we would expect the opposite. We would expect essentially the Republican appointees to be more moderate than the liberal appointees, making the conservative paradox even more paradoxical. So this is where things stood on my research for a couple of years, until I decided to combine this database with a database that Martin and Quinn, 2 political scientists, have created, who calculate how liberal and how conservative the justices are, depending on the coalitions that they form. So how many times does a liberal justice vote with a conservative justice? And that they end up with a score for each justice. Wikipedia has a very nice illustration of their research. Here it is. You see, for example, Douglas here drifting toward the liberal end, or you see Stevens drifting liberal, but then becoming staying about constant. One feature of this is that the whole court may have drifted, but the way that the scores are calculated, every year 0 is at the same place. So most constitutional law scholars would argue that the court today is much more conservative than it was in 1955, but these graphs don't really show that drift. Anyway, once I combine this this data with the decisions of the justices, I now have to pick to ask how do coalitions of 5 get formed, and I propose I test three alternatives. One is that it's the 5 justices who have the more cohesive thinking, essentially comparing the standard deviation of the political positions of the 5 on each side. The next one is that the median will join the side that produces a more agreeable interpretation. So that compares the distance of the median to the average of the 4 on each side. And the third one allows the most strategic action on the side of the justices, which is to compare the median, the distance of the median to the next justice on each side. It turns out that is that will have the most explanatory power, but let me explain it a little more. Essentially, the more extreme justices, the justice that is far to the left and the justice that is far to the right, know that if they insist on their interpretation on some matter, they will lose the vote of the median. So they concede ground, they concede ideological ground, and they approach the median. How do they approach the median? Essentially, they coalesce to the interpretation that is their side proposes that is closest to the median, namely the interpretation that is proposed by the justice who is next to the median. The justice on the liberal side and the justice on the conservative side. And then those two justices, the two justices that are next to the median, are essentially fighting for the vote of the median justice, and in order to form a coalition of 5 and win. There are 2 paradoxes in this from a mathematical perspective. Essentially, there's no solution to the game. The solution is that both nexts join and touch each other at the median, and then the court becomes unanimous. And my co-author in some of the other projects, who was a justice of the Indiana Supreme Court, said when he read this part of the paper, he said, "Wow, this would happen to us all the time. We would start out very differently, and we ended up unanimous." So there is some anecdotal support on it from my co-author, but the true solution to it is that law is not in continuous space like math. It has essentially the possible interpretations are discrete steps, not in continuous interval. Creative interpretations can produce additional locations in that continuum, but they're discrete. And moreover, in order for the justices to say we are the 4 justices who will form the dissent, to say that we want to write a dissent, their position must be sufficiently different, and that difference must be strongly enough felt for them to say we are willing to show to the world that the court was not unanimous. The test, so here's the test of the three models. I run probit regressions So hi Mads, thank you for your question. So let me, before I pass to the test, Mads is asking, what do I mean by discrete? And I have an example, which is very elaborate, but I hope I can get it out. So in criminal law, there are some searches that are considered improper because they violate our privacy, essentially, in some sense. And if they're sufficiently improper, then they trigger an exclusionary rule. And the exclusionary rule means that if the cops searched you improperly and found evidence of the crime, and that led them to further evidence, the next step, that further evidence, can also not be included in the trial against you. So the exclusionary rule says that the product of the search cannot be included as evidence, and everything that springs from it must not be included as evidence. So it's like a causation chain. Everything that evidence led to gets excluded. So the example rests on this concept. We consider the propriety of a search, and the median justice's position is that the search was improper, but it was harmless error, which means that it does not trigger the exclusionary rule, and the defendant's trial can stand. The next liberal justice takes the position that the search is improper, but it triggers the exclusionary rule. So there has to be a new trial excluding this evidence at the very least, or perhaps the next liberal justice would say we'll reverse and say that the conviction was improper. Whereas the next conservative justice on the other side says the search was proper. Well, the liberals can try to obtain the vote of the median justice by proposing an interpretation that's in between the next liberal justices and the medians. For example, they can argue that the search was improper without triggering the exclusionary principle, but does require a remand for a new trial. But there's no additional step in between that and agreeing with the median justice. On the other side, the conservatives can propose an interpretation that the search was improper, but only under these circumstances, and generally such searches are proper. So essentially, concede a little ground toward the median, but not touch the median. I hope Mads, that makes sense. So I go back to the test, and I do the probits, and I also do an OLS clone, from which I take the adjusted R squared to see how much of the variation each theory explains. And what we see is that the first test of comparing the standard deviations on each side explains less than 1% of the variation. The second hypothesis, comparing the distance to the averages of the 4 on each side, explains about 7% of the variation, and the distance to the next justice explains 24% of the variation. So that makes a lot of sense, because this is the most strategic action, and these justices are just about the most strategically sophisticated lawyers we have out there. Alan is pointing out that the voting median is the pivot vote. And that this generates unanimity according to the Hotelling model. Right, yeah, this is an application of the Hotelling model of the median voter, but it is in a multidimensional space, right? So Hotelling is thinking of the median voter in one dimension, and when we think of liberals and conservatives, we think of one dimension from liberal to conservative. But in our previous work, we have shown that judging is happening in many more dimensions. So when we think of liberal to conservative, we're thinking of a reductionist. We're taking a reductionist metric, and the challenge is, what can we learn about the court despite the reductionism of this metric? John McCallan is asking whether their split decisions are more common in certain types of cases. And I've tried various divisions. The database offers the topics of the different decisions, and I couldn't find a way to see that they're more frequent in one or another. Essentially, all the topics seem similar. A different way of thinking about this is that the judges determine which decisions they hear. This is an interesting feature of the American, the Anglo-American Supreme Courts. If the court can dismiss summarily a petition and not hear the petition. So essentially the summary ruling is that the lower court's ruling stands. If the court decides to review a case, that's called granting a certiorari in the United States Supreme Court. And there are two theories: that the court grants certiorari in order to discipline the lower courts. The lower courts are going too far from where the Supreme Court wants them to be, or that the lower courts are, or that the matter is truly interesting and in a gray area, and the Supreme Court accepts it in order to resolve the ambiguity, to resolve the uncertainty. So another way of seeing this phenomenon, that the cases are similar among different topics, is that the judges adjust how they vote to what they perceive the gray area to be. So we might think that in criminal law, the gray area is large, but in business law, the gray area is little. Well, in criminal law, the judges will be picking a wider set of differences in facts, while in business law, the judges will be picking to hear cases from a narrower set of differences in facts. I hope that addresses the question. Anyway, the key next point for me is that now I need to communicate to lawyers how to understand this data that I'm pointing out, that the distance to the next justice explains 24% of the variation. And normally I'd explain here the difference between linear and probit regression. And then I would go to this graph where I start out by only having two data points, showing two data points: the conservative ratio produced by the Breyer composition and the conservative ratio produced by the Goldberg composition. So Breyer was appointed in the early 90s, and Goldberg was appointed in the early 60s. And when Breyer was appointed, the median justice alternated. Actually, it was Kennedy and O'Connor alternating, and whoever was the median justice, the next one was O'Connor or Kennedy, and was extremely close to them. So the distance to the next conservative is very small, and the distance to the next liberal was large. Vice versa, when Goldberg was appointed, the distance from the median, who happened to be Goldberg, from the median to the next liberal was very small, but to the next conservative, who was white, was somewhat larger. So once I explain what the basics of the graph, because it's dynamic, I can now click on this box to show all the data points. And you see that most of them are to the left of the diagonal, and most of them, the distance to the next liberal is greater than to the distance to the next conservative, which explains the conservative paradox. I can also place on this graph now the probit surface, which is there. And since we're running out of time, and I want to open this up for conversation, I'm going to fast forward to the next graph, which is I divide the sample into those in which the justices aligned by political views. Essentially, the 4 liberals vote liberal, the 4 conservatives vote conservative, versus the ones in which the justices vote in a jumbled way. And the ones in which the justices align are the explanatory power of the regression increases dramatically. And the graph, the same graph starts out with Goldberg producing a 0% conservative ratio and Breyer's composition producing an almost 80% conservative ratio. And then when I add the data, all the data points, we see the greater extremes. And then when we add the normal curve of the probit, we see much more of the range from 0 to 1 there. And we can actually also fit the clone and see how different the clone, the linear clone, is from the surface of the probit by turning it, so that we see that the curve of the probit juxtaposed to the linear one. Now, Michael Kelly is asking, it's not just the number of cases, but the relative importance of judgments that matter. Yeah, that I'm not adjusting for, and I don't know for a way to adjust for. So I'll have to put a pin in that and let us talk offline about it. Once we have split the sample into the aligned and the unaligned decisions, the unaligned decisions stop actually displaying the conservative paradox. And why can't I expand this? And essentially, my interpretation of this phenomenon is that the politicians select the justices based on the justices' views on a limited number of dimensions about the law, the dimensions that the politicians consider salient. And there are all these additional dimensions in judging, which are the politicians do not use as a litmus test, but the judges continue to be consistent. Essentially, the judges are following their principles, both in those dimensions for which they were picked, as well as the dimensions that they were not picked. The full article has much more to it about the difference between the first year after an appointment and subsequent years, and how the distance between the next justices determines the fraction of decisions that are aligned, but we don't have time to get that. Michael Kelly is pointing out that we could see look at subsequent citations and put a weight on decisions based on how much they're cited, but we don't. That's not necessarily deterministic, right? So once everybody knows about a decision, if everybody complies with that decision, then there will be no subsequent disputes to make that decision come back up and be cited. So it's not as easy to decide which are the important cases. So let me say that I sped up through the end of that presentation in order to finish on time, and I can stick around for a couple of minutes to answer any questions that appear in the chat. But thank you very much for your attention, and I'll be happy to answer your questions.